This is the special third court matter before the Honorable Madam Justice Mkhulisi Thusi, Honorable Justice Davis, and Honorable Justice Mshwana. It's the matter of Lieutenant General Shadrach Sibiya versus South African Police Services and others, case number 123874 of 2025.
My Lady Presiding, my Lords, my surname is Primid, my initial is K. Justice Davis and Justice Mashwana, I think I've appeared in front of you before, I'm not sure you recall, and Justice Mkhulisi Thusi, I think I became involved in a matter of yours that was taken on appeal, so I haven't appeared in front of you before, and I appear in this matter together with my learned friend Mr. Sangoni, who's to my left, and my pupil, Ms. Matlingwane, whom I understand is being detained by security to sign the register so she can come inside, but she'll be here shortly. And we are instructed by Junaid Cupido and Rory Sang Molloy of Ian Levitt Attorneys, and we appear for Lieutenant General Sibiya in this matter.
As the court, please, my lady and lords, it's good to see you, SJ, good to see you, Council. I appear on behalf of the first and the second respondent, appearing on the instructions of the State Attorney. Thank you.
My lady, I apologize, I can barely hear you.
We've read the head, we've read the paper.
Excellent.
When we argue, you can assume that we discovered in the ground.
Perfect.
Before we start with the argument, there's a request for 3 supplementary affidavits.
Yes.
To cut matters short and to assist you with our prima facie review, we are mindful of allowing the first supplementary affidavit, and what we could see over the fact whatever weight needs to be attached to the answering affidavit, bearing in mind there wasn't an opportunity to file an answer, but there was at least a response to the notice. Mr. Philip, on the basis that it is a factual issue,
Yes.
and the new notice is thereby
Yes.
completed. Regarding the second and third
Yes.
affidavit, our view is introduction of media coverage or other parties extraneous to these conduct doesn't take the matter further, and we are not amenable to allowing those to occur.
I'm not going to push the point. If I've got the first supplementary in, that's all I need for the purposes of today. Of course, we thought filing the second and third would be helpful to the court, but if the court takes a different view, then we abide the court's decision.
Well, then the ruling is that the first supplementary affidavit is then admitted.
Thank you. Thank you, my Lady Presiding, my Lords. Having regard to the fact that the bench has indicated that the papers have been read, can I start out by giving an overall skeleton of where we say this matter is going to go, with the effect that the court ought, with respect to uphold the relief for us. So,
You'll do that bearing in mind what my sister said.
yes, yes.
And of course, bearing in mind that if the first supplementary affidavit in the contents thereof makes the prayer, apart from the urgent prayer, that would be the first substantive prayer 2, the relief therein, the relief sought therein then moved.
No, I don't think it does, with all due respect. And I'll explain why. So, can I start at the beginning and indicate what my submissions are going to be and how I'll develop the argument in front of the court? The first point I'm going to make is an important conceptual framework point, and that is to ask this court to engage this matter as one about the exercise of public power and not an unfair labor practice. And the reason we say that is because Lieutenant General Sibiya places in issue the power of the National Commissioner to deal with him in the way he has been dealt with. Now, Justice Davis, in response directly to the point you put to me, the reason that the subsequent notice in the supplementary affidavit doesn't render the first principal prayer moot is because the delivery of that notice confirms that the objection taken by Lieutenant General Sibiya at the start of the proceedings is good. And it's good.
Yes, but Mr. President, the prayer says that the second respondent's decision to direct the applicant to stay at home pending an investigation be declared as unlawful, void, and no force or effect. Now, whatever argument you might put forward regarding power or not, that notice or that instruction has been overtaken by events. Hence my question, will then the relief based on something which is no longer in effect is in effect moot?
No, with all due respect, that's not correct. And the reason it's not correct is because of the relationship between the first decision, which is what was the subject matter when the launch of the proceedings happened, and how the development of the second notice only serves to make that first decision worse. And if you'll give me an opportunity to develop that argument, I'll come to it when I can, bearing in mind what you've said about mootness. But I'll just say two things quickly in response, if I may. The first one is, Justice Davis, you'll be aware of Justice Wallace's decision in the Supreme Court of Appeal, where the Supreme Court of Appeal in the al-Bashir litigation indicated that even where a matter may be so-called moot, there are compelling interests of justice reasons as to why the court may nonetheless make a declaration. And the point that I will make is that this court should make the declaration for the reasons that I advance.
Yes, but that is a different argument. That involves the concession that if the relief is moot,
No,
you still want a decision on it.
yes,
That's the
yes, correct. So what I'm saying is I'm addressing you in both respects. In the first instance, I'm saying I'm not sure I agree it's moot, and therefore it renders, and for the reasons I'll develop, the decision is unlawful. But to the extent it is moot, then the al-Bashir principle applies. That's, I think, where we are debating, Justice Davis, if I understand that correctly. But the second point I want to make is this, is you'll know that the second substantive prayer Lieutenant General Sibiya seeks from this court is an interdict to prevent prospective disciplinary decisions, and in the alternative to that, he seeks a suspension of any disciplinary decisions that have been taken. And the consequence of that, my lady presiding, my lords, is that even if, Justice Davis, the development of the second notice renders that first prayer moot, which you know I've given you my submission as to what I've said about that, it doesn't detract from the interdictory, alternatively the suspension prayer, because we say that the development of the second notice actually demonstrates that the relief sought in both those substantive prayers are good. So going back to what I was originally saying, once the court engages this as a question of public powers, the court will understand why the original notice and the subsequent notice is a nullity. And I'll develop that in due course. In addition to that, I'm going to make 5 other arguments. So we've just been having the introductory skirmish, if I can call it that, about the conceptual framing of the case. And my submission is going to be is that once the court understands that this is a public powers dispute, the case, with all due respect, falls to be decided in my client's favor, Lieutenant General Sibiya. And the reason for that is because the respondent, the National Commissioner of Police, General Masemola, in fact has no defense available to him, both on the facts and the law. The high watermark of why the stay-at-home order is unlawful is because it did not comply with the mandatory disciplinary regulations that applied to such a decision. That's point number 1. Point number 2 is that to the extent that this disciplinary process runs in parallel with the Commission of Inquiry, General Masemola says, well, it's not going to interfere with the Commission's work. What it's going to do is it's going to help the Commission understand the allegations. Well, we'll accept that, but what we would say is that if that's General Masemola's submission, that makes the case as to why the interdict is good. Because in the first instance, in order to help the Commission of Inquiry, it means that the Masemola disciplinary process has to engage with the subject matter of what the Commission is going to deal with. That's the only way it can help. If it's dealing with something else, it's not going to be of help to the Commission. And then what we say is, given the intersect between that parallel process and the Commission, and given that there are questions about General Masemola's independence, his conflict of interest, his mala fides, and so on, that there is no principal reason as to why that parallel process should be allowed to proceed in circumstances where the Commission will do the disciplining in terms of the terms of reference that the President gave to it. Because one of the issues that the President says that the Commission must investigate is whether or not disciplinary measures should be taken against people implicated in those allegations. In other words, on General Mkwanazi's version, my client, Lieutenant General Sibiya, and that's why the Commission must be allowed to perform its function without interference by the National Commission. The third, oh, I'm sorry, Justice Moshawana.
Just for my understanding, you make reference to the exercise of public power.
Yes.
Is my understanding correct that you are now suggesting that the decision to stay at home amounts to an exercise of public power?
Yes, that is the suggestion, correct.
And secondly, the fact that, or the issues that are to be investigated
Yes.
in the commission
Yes.
are issues that did not arise only the other day.
Yes.
Arisen many moons and years ago.
Yes.
Now, on the papers of the report, was alleged or suggested that certain instructions were given and those instructions were fulfilled. How is that connected to the judicial committee?
I beg your pardon, Justice Moshawana, can you repeat?
How is the allegation of misconduct that is placed at the door of the army related to the Judicial Commission of Inquiry? Taking into account that it investigates matters of public interest that have many years ago.
Yes. 001-63. You'll see it's the Government Gazette. I don't know if your Lordship has it. I'll ask one of my juniors to direct the court.
Before we go to the Government Gazette says on the Commission, what my brother asked is, if the allegation is by the National Commissioner, look, if the ministerial task team has to be disbanded, it must be done in an orderly fashion.
Yes.
Phased, in a phased fashion.
Yes.
To jeopardize any other investigation.
Yes.
Investigatory processes or
Yes.
endanger the safety of witnesses.
Yes, my Lord.
If you gave an instruction to say, this is what should happen, and the answer affidavit says, and this is what he suspected did not happen.
Yes, my Lord.
That's why he wants to proceed with disciplinary proceedings against your client. How does that interfere, my brother asked, what is now taking place between January of this year and now, with what happened long ago with the Commission is trusting?
Well, I'm going to come to that in a moment, and I will take some time to develop those submissions because I think the factual chronology of how the disciplinary notices come about is very important. But with all due respect, the reason that there is an intersection between those two things actually comes from a judgment of Justice Moshawana in the matter of the recent RAF CEO, Mr. Letsowalo versus the Road Accident Fund and the board of the Road Accident Fund. And in paragraph 16, of that judgment, Justice Moshowana says the following, and this is why we're coming to that point that you've put to me, Justice Davis.
Actually, Judge Moshowana as well.
Well, yes, that's right, but I'm relying on Judge Moshowana to answer you and then go back to Judge Moshowana if you don't mind. But Justice Moshowana says, as a departure point, a thing is unlawful if it is not authorized by the law. And then he goes on to say, with all due respect, before considering the lawfulness of the suspension, this court must address the issue of the source of the power to suspend. So why that is an answer to you, Justice Davis, with all due respect, is I would say in the way you are positing the question to me, what does the Commission have to do with things too long ago, puts the cart before the horse. The correct starting point is what is the source of the authority for any suspension decision to be taken. And if we can demonstrate that there is no source of authority to take any disciplinary action in the manner in which it has been taken against Lieutenant General Sibiya, that there may be some merit to the allegations or no merit to the allegations doesn't in actual fact arise, because what Justice Moshowana correctly says, with all due respect, Justice Moshowana, is that you need to start with the source of the power. Because if the source of the power doesn't permit the administrative action in question, then everything that follows is tainted by unlawfulness. And that, with respect, is the submission we make in response to Justice Davis and Justice Moshowana, having regard to the question you asked me, is that to simply allow these allegations to be tested in due course under the General Masemola's process, never mind that the Commission has now come about, would in theory require my client to subject himself to what we say is an unlawful disciplinary process. So the so-called damage or the so-called harm that usually arises in these unfair labor practice type of cases, and as to whether or not the harm will be remedied in the hearing in due course, doesn't arise here because we're asking an earlier question. And the earlier question is, could General Masemola take the decision that he did to suspend in the way that we did? And the answer is no. And if the answer to that is no, then we say, with all due respect, that cuts as the first substantive prayer is concerned, because that suspension would be unlawful. And then what we submit is that the further knock-on consequence of that is that the interdict ought to be upheld. But Justice Moshowana, I was giving you a reference, and the reference I gave you was 001-63, where you will see under the heading where it says Schedule Terms of Reference of the Judicial Commission of Inquiry, you will see that what is identified in about line 3 of that second paragraph is the allegations made by Lieutenant General Mkhwanazi. And those allegations are made the subject of the Commission of Inquiry, and the Commission must do the things which are indicated, for example, over the page at 001-64, paragraph 2, things like facilitation of organized crime, suppression or manipulation of investigations, inducement into criminal or other unlawful actions, commission of any other criminal offenses, and so on. And the reason that's relevant, with all due respect to the question you posited to me, Justice Moshowana, is that never mind the historical genesis of these allegations, whether or not they come from 2018 or whether or not they come from 2024 or 2023, the fact of the matter is that the President says all of those allegations must now serve in front of the Commission, and the Commission is the correct body to investigate these things. And you'll know from the founding papers, we say the reason the Commission is the appropriate body to investigate these things, as opposed to General Masemola, is for the exact reason that Justice Davis posits at me. And that is that General Masemola himself is heavily intertwined in the factual matrix that gives rise to the basis for the suspension of General Sibiya. And considering that General Masemola sits in the superior position in that suspension decision as against General Sibiya, the point to be made, and this is why we ask for the interdictory, alternatively suspensive relief, is that a conflicted party can't sit as the judge in their own cause. Because remember, what General Masemola is testing is whether or not General Sibiya's conduct complied with his instructions, based on what he decided. But he's also the body who makes the decision to suspend. And we say that's the conflict which demonstrates why General Masemola's processes are inappropriate, and given that General Sibiya will be disciplined if there is a case to answer by the Commission.
So you say if the National Commissioner issues a lawful order and a subordinate disobeys it, the National Commissioner is then precluded from instituting disciplinary proceedings?
No, with all due respect, that's not my submission at all. My submission was a bit more nuanced than that. My submission wasn't a bland proposition that the National Commissioner's power is ousted. The point I made as a rule of law point in my debate, in my answer to Justice Moshawana, is it about the degree to which the compliance with the disciplinary regulations occurs. And as I said, I'm going to develop the point to demonstrate why, even if General Masemola considers his order to have been lawful, he didn't comply with the mandatory prescripts of the disciplinary regulation, with the effect that paragraph 16 of Justice Moshawana's judgment in the Letswaolo RAF matter overtakes whatever comes thereafter. So that's the point I'm making, with all due respect. But in any event, yes, my lord.
Unless if my reading of the papers is not correct, we know as a matter of fact that there was that instruction to stay at home.
Mm-hmm.
And we know that the applicant is actually questioned on two bases regarding the terms of the power.
Yes.
But the issue around or from the paper, the next commissioner says the following: I issued a particular instruction,
Yes.
and that particular instruction was not followed.
Yes.
Now, from an employer and employee,
Yes.
relationship, that appears to be a case for insubordination on the facts
Yes.
as alleged.
Yes.
And hence, I needed to make a connection between what the Judicial Commission is going to investigate
Yes.
and these allegations
Yes.
that are placed before the applicant.
Yes.
For me, I'm struggling to make a connection between the two, but perhaps you can make use of this to make me understand what then is the relationship. That it goes to what my brother asked, that is there a suggestion that if the National Commission issues an instruction, a lawful order, and it is not complied with,
Yes.
that would prevent the National Commissioner to take disciplinary steps.
So, Justice Moshawana, if you've got 001-64 in front of you, we were talking about that a short while ago, you will see at the top of the page, paragraph 2.2 refers to suppression or manipulation of investigations. Does your lordship have it?
No, still 2 points?
2.
Yes.
Suppression or manipulation of investigations.
Past investigation.
Yes. But the point that I'm making is that to the extent that it becomes a question of compliance with General Masemola's instruction about what to do with ongoing investigations or not to do with ongoing investigations, that clearly falls within the subject matter of the Commission of Inquiry. The point that I'm making, and perhaps this is where the disconnect has arisen, so let me take it in 2 parts. The point that I'm making is that before we can even get into a labor type of analysis of, is this a fair practice, has the charge been adequately demonstrated, is the charge sheet specifically detailed, and all those kinds of wonderful things, we have to go back to the source of the power. And if I can demonstrate that there's no source of the power, then with all due respect, it doesn't matter whether there is some currency to General Masemola's allegations or there aren't, because if I can demonstrate that the way in which he sought to discipline fell outside the disciplinary regulations, then as a matter of the rule of law, that's gone. And so insofar as the notice of motion is concerned, you'll know that's my prayer too. Now, let's talk about then the intersection between this 2.2 and the Commission's mandate. The point that we make to you, and you'll know the test for an interim interdict, prima facie right open to some doubt, coupled with the other requirements. But let me stick with prima facie right open to some doubt just for the time being. It is incontrovertible that Lieutenant General Masemola, Lieutenant General Sibiya, I beg your pardon, has a right to just administrative action. If we just take it at first principles. And what we say is that if there's no authority ipso facto, that's unjust administrative action. But what you also know is that Lieutenant General Sibiya goes a little bit further. And he says to you, yes, I can understand that the Commissioner has a right to discipline me. But look at the Commissioner's involvement itself in the current round of what he wants to discipline me for. And what Lieutenant General Sibiya says in response to that is, hold his process. Let me go to the Commission. They are independent. They are neutral. They are not implicated in the way that the papers demonstrate Lieutenant General Masemola is.
Sorry, Mr. President, to interrupt. I don't follow. Is your argument, yes, he generally has the power because he's implicated, he may have exercised it? Or what is the argument? Because you say, before we look at what he says, look at what he's involved in and what he's implicated in. But I don't understand legal logic. Does he have the power or doesn't he have the power? Or you say he has the power but he shouldn't exercise it because it's implicated?
Second, not first.
The second one. So there is the source of power.
No, the source...
The source of power should not be exercised in this instance.
Yep.
Well, that's why I don't understand. So two things. So the one thing is there is the source of power. If he'd not been implicated, not been mentioned or any of this, then he could have done it.
Yeah, that's correct. I accept that. I accept that.
He has the power to discipline.
He has the power to discipline, but the discipline has to comply with the regulations. And if I can show you that there's no stay-at-home power in the regulations, then the order to stay at home is unlawful, in the same way that I've been debating with Justice Moshawana. That's the point. But I think this is the important...
I'm now more confused. I want to understand, and I think I understood the point raised by my brother to be the following. He has the power, but because he's an implicated person, he cannot exercise that power. And you seem to have conceded that that is the position.
No.
Yes.
Can I?
Now it seems in your follow-up, you make a submission that he doesn't have the powers arising from the regulations. So in other words, his power.
Let's go to page 001 of the notice of motion, please.
Can I just find out the source of that power? Because my understanding from your submissions was that he does have the power. But
As prescribed by the regulation.
But in terms of the regulations, those powers were exercised wrong.
Correct. Unlawfully. Yes, that's right. So if we can just go to page 001-3 at prayer 2 of the notice of motion. What my lady presiding has just engaged me on is that prayer, which is, if he didn't have the power to issue the stay-at-home order, then it's unlawful and it falls to be set aside or not implemented in the terms set out there. That's what my lady and I were discussing. Where the issue of the conflict arises and how that implicates the ability of the National Commissioner to make a decision in the context of a disciplinary process arises in the context of what we say is prayers 3 and 4 of the notice of motion. So the conflict per se is not to evidence the lack of power. It's to say that the court, in the exercise of its discretion for the interdictory relief, should not permit General Masemola to persist with the parallel process in circumstances where, for example, he is conflicted in the applicant's version, and where the Commission can do as good a job as General Masemola in allowing General Sibiya to be disciplined. That's the point. And so the additional points that I was positing to my Lord Justice Mashawana regarding conflict, regarding the fact that the Commission is independent, regarding the fact that the Commission has this in its terms of reference, all point to the fact that we say sustain the prayers sought in prayers 3 and 4 of the notice of motion on 001-3. That's the point. But let me go to my first point perhaps, because I think that's where this tension in the debate arises, and I think that would be helpful to us. So the first thing I want to say as a clarificatory point, if I may, is that jurisdiction is not in dispute. And because jurisdiction is not in dispute, what the court will know is that the subject matter for jurisdiction is determined by the pleadings. Kaaba, paragraph 77. My Lord Justice Mashawana shakes his head. My Lord knows the authority well. The consequence of that is that when the court is asked to engage this matter, it has to engage its rule of law jurisdiction rather than what might be its concurrent labor law jurisdiction, because the pleadings in this matter place squarely in issue the power of General Masemola to take the decision he did. That's really what this matter is about. And at the risk of confusing things, what I am going to posit is that that's why this is a rule of law issue, not a so-called labor fairness issue. This is about something more fundamental, and that is about whether or not the National Commissioner, as the repository of the public power, had the power to do what he did in the first place. And the answer to that, we submit, is that he didn't. And I'll demonstrate this as I develop the submission. So the first thing I'd like to ask the court to have regard to is a judgment of the Labour Court in Johannesburg, a judgment of Vuma versus National Commissioner of the South African Police Service. We have hard copies. I don't know if we should hand it up or upload it after the hearing. It's a long reference, Vuma versus National Commissioner of the South African Police Service and others, J1297/22, square brackets 22, ZAC JHB 278. Okay, J1297/2022, square bracket 2022, ZACJHB 278. We'll make sure it's uploaded. And in paragraph 15 of that judgment, what the court... I think I said Labour Court. I think I should have said Labour Appeal Court.
Is that a Labour Appeal Court judgment?
Yeah. Hold on one second, Justice Mashawana. No, it's ZALC JHB, so it's the Labour Court Johannesburg. Sorry, I was just looking at the Safley hyperlink to establish that. But what happens in paragraphs 13 and 14 of that judgment is the debate we were having earlier, and that is, why is it that all of these complaints about the way in which the disciplinary process is being conducted, can't that be remedied at the hearing in due course? And what the court does there at paragraphs 13 and 14 of that judgment, but particularly paragraph 15 of that judgment, and that's the one we're relying on particularly, is that the court says that that is correct. The veracity, I'm now reading, the veracity of the allegations made against the applicant will be tested in due course in an appropriate forum. There is no evidence to suggest that the first respondent, in suspending the applicant for the purpose of an investigation into the matters in the SIU report, is in any way arbitrary, capricious, malicious. thus placing the case in the category of the exceptional. So what the Labour Court says there is that where you take a rule of law point in the way that we are taking a rule of law point to the exercise of the power, that makes the matter an exceptional matter which triggers the rule of law jurisdiction of the High Court to give us the relief that we're seeking. Because we're no longer in the world of, is this a fair labor practice or an unfair labor practice? We're actually in the world of, should I even be here in the first place? And if the answer to that is no, you shouldn't be here in the first place, then everything that follows thereafter, as I've said already, is tainted by the unlawfulness and falls to be set aside. That's why in Qaba, and I apologize, I said Qaba 77 earlier, actually I meant Qaba 75, the court was at pains to say in Qaba at para 75 is that as long as a party is able to plead the facts to sustain a cause of administrative action that is cognizable in the High Court, then that would fall within the jurisdiction of the High Court, and the High Court would have the ability to invalidate a labor proceeding on the basis of the fact that it's an unjust administrative action. I apologize.
Just bear in mind, the jurisdiction is not the issue.
Yes.
So, you were taking us along another path?
No, with all due respect, I'm not. The reason that I'm highlighting jurisdiction in the context of this case and the fact that it's not in dispute means that we are squarely in the rule of law territory. And the point that I am making is we can't, with all due respect, engage that second order of questions that Justice Davis was putting to me and that Justice Moshawana was putting to me if you don't get out of the starting blocks, which is the rule of law point that I'm saying the regulation doesn't permit the National Commissioner to do what he's done here. That's the point I'm making with all due respect. So the fact that jurisdiction is not placed in dispute by General Masemola shifts the debate more in General Sibiya's favor, because then it becomes a source of power question. And if I can demonstrate, as I'm trying to develop the point, that there is no source of power that permits the stay-at-home decision, then that means that everything that flows from that decision is tainted by the unlawfulness. So that's why I was referring to...
You say if the stay-at-home decision was unlawful, do you then mean to say that the subsequent notice of intention to suspend is also unlawful?
Yes.
How so?
May I develop that in due course? I'll come to it a bit later if I can.
Let's get to the development point.
Yes, it happens to be the case when the bench is particularly active. Not much progress can be made, but I am trying. As I was saying, in the Vuma matter, that's the threshold. The exceptionality takes it out of the normal labor court type of process. And in the Labor Appeal Court, in a decision of Cibane, that's C-I-B-A-N-E, and the citation for the one that I'm looking at is in the Labor Appeal Court, Cibane and another versus Premier of KwaZulu-Natal and others. We'll also make sure that is uploaded. At paragraphs 21, 22, 23, 24, 25, 27, 28, and 30 of that judgment emphasizes the point that I'm making, and that is, if, and I'm now paraphrasing what is said in paragraph 30 of that judgment, if a litigant can disclose a ground for review permissible in law, then the subsequent decision falls to be reviewed and set aside. So we go back to the powers point, which is what I was developing. And the importance of that, with all due respect, is to demonstrate that if the regulation doesn't permit that to happen, then the decision, the first one, is unlawful, and the second one is also unlawful, because then you're in the situation of functus officio, you're then in the situation of attempting to approbate and reprobate. You've chosen one course of conduct, a complaint was raised, you've then now taken an alternative course of conduct, and so on. And those are the traditional review grounds that we rely upon in order to say that all of those disciplinary decisions are unlawful as a matter of the rule of law and fall to be reviewed and set aside. But Justice Mqudisi Tusi presiding, you would recognize this issue because not too long ago in the decision of Masemola, the 2024 Masemola decision against the National Commissioner of Police, in considering an interdict where a review was pending. Now obviously we're in slightly different grounds because we say that if we get that first substantive prayer, then the review is granted ipso facto. But we rely on Justice my lady's presiding, we rely on that judgment, paragraph 22 thereof, because what your ladyship said in that judgment is that where the review was pending and there was cogency and strength to the review, that an interdict could be granted in circumstances where the grounds of review can be shown. So we say that on the strength of that authority, the proposition for both the unlawfulness prayer and the interdict prayer gets stronger because of the fact that we're not in an unfair labor practice terrain, we're in a rule of law terrain. And so let's just look at the regulation.
May I just establish this? From the reading of the paper, it appears to be the National Commissioner's case that when I exercised or issued an instruction to stay at home, I was not exercising powers sourced from the regulation.
Yes, but
Now, if this was accepted, then it really takes away the argument that we did not comply with the regulation.
yes,
Saying, I did not
yes,
exercise powers emanating from
yes,
that.
yes,
It is the applicant himself
Yeah.
who is suggesting that the person who exercised the power must have sourced the powers from somewhere.
okay. Can I give you 5 authorities in response to the question as to why this court cannot accept that proposition? If I may.
Well, answer the question.
I will. Because what you know, first principles, affordable medicines. Public officials are not entitled to exercise power that they don't have in terms of an enabling statute. That's point number 1. So for the court to accept what the National Commissioner says, you would have to look at an instrument that enables him to make the decision that he says he's entitled to make. What does the National Commissioner say the source of his authority is? The National Commissioner says it's Section 207 of the Constitution. But what's the problem with that? Section 207(2) of the Constitution says that the National Commissioner exercises his disciplinary powers and his managerial powers of the SAPS pursuant to the policies and regulations and the legislation that gives effect to Section 207. So the problem for the National Commissioner is that he can't have recourse to the Constitution because he has a subsidiarity problem. He's got the SAPS Act and the disciplinary regulations promulgated under the SAPS Act standing in his way that does not permit him to exercise a so-called original constitutional power, because the Constitutional Court in My Vote Counts and in Masuku said that where there is a specific piece of legislation, be it primary legislation or subordinate legislation, if I use that old-fashioned term, like disciplinary regulations, then you have to go there first. So, how do we read Masuku and NVC on one hand about subsidiarity and then affordable medicines on the other? The point is this, is that if you don't have the power in the instrument which regulates your conduct, you can't simply say, oh well, I'm just going to rely on the Constitution blandly, because then you're exercising a power that you don't have, particularly in circumstances where Section 207 of the Constitution itself tells you, Commissioner of Police, you exercise this power in accordance with the subsequent legislation that has been promulgated under the section. But with all due respect, those are arguments I've made. Let's give you two more authorities, if I may, that my learned friend relies upon. My learned friend for General Masemola relies on the case of Freedom Under Law versus National Director of Public Prosecutions. And the paragraphs cited from that judgment are paragraphs 206, 217, and 218. And I'd just like to read out paragraphs 217 and 218, if I may, because this is the direct response to you, Justice Moshowana. It says this: the second prong of Foole's attack on these decisions is that the acting commissioner failed to protect the integrity of the SAPS and to abide by its legislative framework. Every organ of state is required to exercise the powers conferred upon it accountably, responsively, and openly, and to protect the institution by ensuring the proper exercise. That's 217. 218 goes on to say the following: to ensure the proper functioning of the SAPS, the Commissioner, in discharging obligations under the SAPS Act, must protect and give effect to the SAPS discipline regulations. So what the courts have consistently said is that if there is a specific instrument that pigeonholes your disciplinary powers one way or another, you can't, when that instrument doesn't give you the power you want to exercise, invent that by having regard to Section 207 of the Constitution, because then you're inventing powers and applying those powers beyond the scope of the enabling instrument. And if the disciplinary regulations as the enabling instrument don't give you that power, then you're not allowed to invent that power. That's a trite principle of public law. That's the way in which the exercise of public power is held to constitutional constraint. And just think about why, with all due respect, that is the case. If a public functionary who is subject to a piece of legislation comes across a certain factual scenario that the legislation doesn't give them power to deal with, nor does the legislation say they have the discretion to deal with it in any manner whatsoever they choose to do so. If that public functionary chooses to deal with that, they are then creating a power for themselves that they don't have. And that's how constitutional control of public powers works in these kinds of proceedings, Justice Moshowana. And so the answer is, you can't sidestep that. You can't go directly to the Constitution. You can't invent the power, because the underlying instrument doesn't enable you to do that in the first place. So that's the answer with the five authorities.
My understanding of the subsidiarity principle is that where you would want to exercise a particular right, you would not claim that right from the Bill of Rights if there is a legislation
Yes.
that gives effect
Yes.
to that right.
Yes.
Now, in this instance, the National Commission does not seem to exercise a particular right that is protected by the Constitution. He is exercising power, and he is saying, as you correctly pointed out to the RAF judge, he's saying the source of my power is Section 207. Section 207 allows, among other things, for me to manage the police.
Can we,
That's what
yes, let's just go to Section 207(2) of the Constitution, if we may, because I think that's an important thing for us to read together. Section 207(2) says the following: the National Commissioner must, so peremptory, exercise control over and manage the police service, and here's the important part, in accordance with the national policing policy and the directions of the cabinet member responsible for policing. So the point that we make is that the National Commissioner can't say my power is sourced in 207 generally, when 207 itself tells you, National Commissioner, you can only exercise your power in these specific ways. In terms of what it says in terms of the national policing policy and the directions of the cabinet minister responsible for police. And what we say to you, Justice Mashawana, is that the disciplinary regulations themselves form part and parcel of the national policing policy to the extent it regulates discipline. And in circumstances where the disciplinary regulations don't provide for a particular type of scenario and to exercise a particular type of power, the National Commissioner can't say, well, okay, this disciplinary regulation doesn't give me what I want, I'm going back to the Constitution, when the Constitution itself tells you, go back to the legislation or the regulation that is promulgated in terms of this section. That's how subsidiarity works. Because if that position was correct, as I've said already, it would mean that authorities like affordable medicines and pharmaceutical manufacturers from the Constitutional Court would be meaningless, because all of those judgments were testing whether or not the conduct by the public functionary was authorized by the enabling statute. And if the answer to that is, well, when the enabling statute doesn't give me the power, I'm allowed to invent it, that breaches the fundamental principle of constitutional control of public power that has come from those long line of cases, pharmaceutical manufacturers, affordable medicines, and so on. So the point is that he can't do that, with all due respect. He's bound to what the regulations either say or don't say. And if it doesn't allow him to act in a particular way, he's not allowed to act outside it. That's the point.
If you look at section 207, carefully look at it, it seems to be providing two parts. One, exercise control. Two, manage. And in terms of management is by the national policing policy,
Yes.
or the directions of the minister.
Yes.
Now, what would your submission be on what could be exercise of control? Because it says exercise of control and, does it not say?
No, it doesn't say exercise. It says exercise control over and manage, but then that's qualified by in accordance with. So it's not a free-floating power. It's a power that's prescribed by the legislation that's promulgated in terms of the section. The subordinate...
Or one power?
I beg your pardon?
Is it two powers emanating from 207 or only one power?
I think we're speaking cross purposes, with all due respect. Whether it's one power or two powers doesn't matter. What matters more, with all due respect, is the source of authority. And that's the point that we're making, is that if the regulation doesn't permit the conduct that is objected to, then you can't go back here and say, well, I'm just exercising either the control power or the management power, when both of those powers in terms of the section explicitly says you do that in accordance with the national policing policy.
Through the fog and get to the allegation. 8.26 around INSTATED, where the Commissioner said, I must note at this stage, the stay-at-home order was in no way intended to be a precautionary suspension in accordance with the African Police Service disciplinary regulation 2016. What did he do? He said, merely to ensure that the applicant, who is a high-ranking deputy national commissioner, and also in his instruction, he said, these allegations are serious. He says it was not present in his office while the preliminary investigation took place, and you're comfortable with the preliminary investigation notice that was duly given, to embarrass him and to ensure that witnesses would freely voluntarily participate in such an investigation without the pressure or possible intimidation created by the presence. Now, in your debate with my little brother, you went back to the source and you said the Constitution and the national legislation policy. Do you state that what the Commissioner says there he was not empowered to do in terms of the Constitution, National Police Act, policy, regulation? Wasn't he entitled to say,
Not in the
senior officer, please stand aside, don't get close to the investigation, there might be embarrassment
Yep.
to one, on the other hand,
Yep.
witnesses might not. You say he may not have said so.
Not in the manner he did so. And let me tell you why.
What manner? He said
Let's go to the regulations, please, if we may. They're an annexure in the founding affidavit. May I develop the submission with all due respect? I'm trying to. May I ask if we can look at the regulations, please?
Just stay away. It's almost as you stay away from the station, stay away from the base.
Yes. Just on that point, just on that point, the point of the matter is that when the suspension notice came out, the first one, that was not even a reason in the suspension notice. So that reason arises from the answering affidavit for the first time when the challenge was put in play as to why are you placing me on a precautionary suspension. But this is the point, with all due respect, about the form over substance argument that the National Commissioner has raised, to say,
You want to paint the stay-at-home order with the paint that says suspension notice.
and that is its consequence if it has no statutory authority for that.
That's argument.
Yes.
All right, so this order to say stay away while we investigate, not to embarrass yourself, and to allow witnesses to participate in the investigation, you say that should be read to amount to a suspension.
Yes.
Was there any impact on his salary?
No.
Any impact on his benefits?
No.
Any impact on his security?
No.
How could it be a suspension notice?
Because he's at home. Because he's at home, and there is a dispute about whether or not his security was provided or not provided. There's two instances of.
Understand the applicant's argument is paragraph 826, stay at home instruction equals suspension.
Yes.
Do I have that correct?
Yes. And I'm saying that he doesn't have that power because of the subsidiarity problem. So can we go to the regulations, please? Regulation 6.2 in particular. That you will find on case lines at 001-93. And let's look at what it says. 001-93. Give me 1 second, please. Sorry, it's not to 6, it's 2. Go to 2. Regulation 2, Regulation 2. Yes, thank you, Regulation 2. I apologize, I gave you the wrong information. It wasn't Regulation 6, it's Regulation 2 that I want to draw the court's attention to. And I just want to point out the following.
Where does it appear? You are about to give us a reference.
Yes, can you just give me the page reference? It's 001-88. And just look at what Regulation 2.1 says. Based on the agreement reached between the employer and all the unions admitted to the bargaining council, these regulations apply to the employer and all its employees falling within the registered scope of said council. And then sub 2 says these regulations apply to members of the senior management service of the service, excluding the National Commissioner and the Provincial Commissioner. So the reason I want to start there is because the regulations tell you that they explicitly apply to Lieutenant General Sibiya because he is subject to the disciplinary power of the regulations. That's the starting point I want to make. So if we accept that as the starting point, let's test this argument about was it permitted or not permitted. And in order for us to do that, could I ask the court please to turn up the stay-at-home order, the letter containing the stay-at-home order. If I've got that right, it's Annexure SS1, which is at 001-58. Yes. Yes. Yes.
So you directed us to the stay at home.
Well, I'm going to deal with both of them together, SS1 and SS2 in turn. As Justice Davis correctly said, the stay-at-home proper is the next one, on the next page, but I'm starting here at SS1. Does my Lord have it?
Yes.
So you'll see on SS1, look at what it says. It says there, under paragraph 1, you are hereby notified of alleged misconduct and a pending investigation against you in terms of Regulation 8.1 of the discipline regulations. Okay? And then what it says in sub 1, 2, and 3, all of these so-called allegations relate to what General Mkhwanazi said in his press conference. And we don't have to invent that. We can look directly at the wording. In 1.1 it references him, in 1.2 it references him, and in 1.3 following on from that it also references him in respect of Mr. Matlala. And if you look at the bottom of that page, that is dated with a stamp date 2025-07 July 14. So this is the notice of alleged misconduct in terms of 8.1, and then look at what happens immediately on that same day. Turn over the page to SS2 at page 001-59. And it says, following the media briefing, and I'm reading from paragraph 2, following the media briefing from the Provincial Commissioner KwaZulu-Natal on 6 July, this office is gravely alarmed by the allegations leveled against yourself and the subsequent commission inquiry established by the President. Given the seriousness of the allegations, you are hereby instructed to stay at home pending the outcome of an investigation. So the relationship, it seems like, between these two things is the 8.1 notice says here's the notice of alleged misconduct, and this thing that comes at SS2 is saying you must stay at home. Now, before I examine this against the regulation, Justice Davis, may I just point something out insofar as what comes out in the answering affidavit? Remember, I think you said to me it was 8.26 in the answering affidavit where the National Commissioner's justification was you're going to interfere, I need to protect the integrity of this process and so on. Now remember, the suspension notice, the second suspension notice that we were talking about earlier comes after the answering affidavit, okay? So before the answering affidavit was filed, the only documents that gave effect to keeping General Sibiya at home were these two documents. And the problem for the answering affidavit to disclose those reasons, I've asked you to stay at home or whatever the case is because you're going to threaten the investigation, your presence is going to intimidate someone, is that that doesn't feature anywhere in SS1 or SS2. And yes, it does, because what you know from Long versus SA Breweries, and let's maybe go there together, I think it's paragraph 25 of Long versus SA Breweries. Both my learned friend and I rely on that authority. If you'll bear with me for 1 second. Do you have Long? Here we are. I apologize, I found it. Thank you, I'm indebted. Anyway, the point is that what was established in Long is that the suspension must serve to protect the integrity of the investigation or process or mitigate risks to the employer whilst such an investigation or process is ongoing. That's what the High Court said, and you know that the Constitutional Court didn't interfere with the High Court's decision. Now, why that's relevant, Justice Davis, is that...
Was that the High Court or the Labour Court?
This, I apologize, the Labour Court, and that was not interfered with by the Constitutional Court. Justice Moshawana is entirely correct. But Justice Davis, going back to the engagement we were having, the reason that's relevant is because you also know from public law principles that when a decision maker takes a decision, their reasons are corroborated by the contemporaneous evidence at the time. It's insufficient for them to advance reasons in the answering affidavit where they don't appear in the original document that captures the reasons for acting. So why, with all due respect, I say that the absence of those reasons in SS1 and SS2 is relevant is because you can't claim in the answering affidavit, I'm protecting an investigation, when at the time you're communicating stay at home, you don't say the reason I'm telling you to stay at home is because I'm protecting an investigation. So that disconnect, both factually and legally, thank you. No, it doesn't. And it doesn't for the reason that Justice Moshawana said in the Letswaolo matter. When you're in V-Rays in the disciplinary regulations, then it's not administrative action, that's a fair labor practice question. But if you're in an ultra V-Rays scenario, that's when it's administrative action. And the point that we have been making is that because there's no authority for the stay-at-home decision, we're in the ultra V-Rays admin action ground and not in the intra V-Rays fair labor practices ground. So it doesn't have the effect of elevating every decision to administrative action. It's only those targeted ones which fall outside the enabling instrument. So
sorry, Councillor, I think what I understand my brother can ask you is the National Commission says in the answering affidavit, I did not exercise powers emanating from the regulation, i.e. I did not put the applicant on a precautionary.
yes,
And in order to establish whether that is possibly correct, if you look at SS2,
yes,
nowhere is there reference to precautionary suspension. Nowhere is there reference
Yes.
to the clause that
Yes.
deals with precautionary suspension.
that's exactly the point.
What is apparent from these notices is that, 3, given the seriousness of the said allegation, you are hereby instructed
Yes,
to stay at home
Yes.
pending the outcome of the
yes. And the reason for the stay-at-home instruction explicitly is because of the media briefing from the Provincial Commissioner of KwaZulu-Natal and the allegations that he stated. So it's not a stay-at-home order given in the ether, it's a stay-at-home order given specifically in response to those allegations. And that brings us back to the central question of, do you have the power to instruct to stay at home where the purpose of your stay-at-home instruction, and let's adopt what they say in the answering affidavit, for the sake of argument at least, is to preserve some or other instruction. Now, if that is the case, then your stay-at-home order, in effect, is actually a precautionary suspension, because remember, that's what the answering affidavit tells you. It's telling you stay at home so I can protect an investigation. Or, if it's not a precautionary suspension and it's just a stay-at-home order on its own, then it's still unlawful because there's no authority for such an order in the disciplinary regulation. That's the point, with all due respect.
But why do you want to go to the disciplinary regulations when the repository of power, we don't know where, for a moment let's assume that he has no powers at all. He has no power, but he did something.
Yes.
He did something by instructing the applicant to stay at home. Now, why do you want to then persist and say that that which he did can only emanate from the disciplinary regulations and not, for instance, from the Constitution?
My Lord, I've answered that question, and that's subsidiarity, with all due respect. If you look at 001-87, which is the regulation, you will see that under paragraph C, the definition of employee means any person employed by the SAPS, excluding the National Commissioner and the Provincial Commissioner, so that's Lieutenant General Sibiya, because he is a deputy national commissioner. And then it goes on to, and this takes us back to the point that we discussed earlier about Regulation 2 and the scope of the regulations. And so the point is that the regulations are the instrument which manage discipline in the SAPS. And I see Justice Moshawana shrugs at me. The point is, with all due respect, is that if the Constitutional Court's authority tells you that when a subsequent piece of legislation, either a principal piece of legislation in the form of an act, or a policy, or a set of regulations, is the direct regulatory instrument of a topic on the same subject matter, you are not allowed to look behind it because the principle of subsidiarity stands in your way. So it means that for any decision that has a disciplinary consequence, it is only the disciplinary regulations that apply. And so if the National Commissioner's case, as it is that I didn't act in terms of the disciplinary regulations, I acted directly in terms of the Constitution, one, he concedes then that he's breached the principle of subsidiarity, but two, more than that, it illustrates that he acted without authority, because he did something that the enabling instrument didn't allow him to do, and that, with all due respect, takes us back to paragraph 16 of Letswaolo and the RAF matter. You can't do it, it's a nullity, and therefore it can have no consequence or purchase in the context of what happens with the general. But let's go back to SS1 and SS2 in the way that we were discussing them. Because what you will see is that, and now I'm looking at 001-96, as the court pleases. Nice to meet you, likewise.
What is your name?
Camille Premid. You can ask my attorney, she'll tell you. Thanks.
Oh yeah, we understand. The phone is fixated on this constitution.
What I don't understand is that they like perfect, right? So
It's not away from the screen. Sometimes with these screens you notice that they don't go off the break.
all of my shit is here though.
Yeah, so sub 2 configuring isolation is great with sub 1. And then what are you asking? You're asking for
Can someone find section 40 of the SAPS Act? Section 40 of the SAPS Act.
Yeah, they have it here. Okay. Like I said,
Hello?
interacting state.
Fine, and you? Good. Have you been here since the start?
Yes.
Are you enjoying the debate?
I'm listening. How are you? All right. I found it very serious. How are you? Okay. There's only one thing that I wanted to just
Thank you. Having had the benefit of the tea break, and at the risk of reopening an old can of worms, I'm going to try and engage Justice Moshowana on this subsidiarity point in this way, if I may. If we can go to section 207 of the Constitution. My Lord, I think it's not uploaded on case lines, but we'll make sure it's uploaded in due course. I apologize for that. Now, if you look at 207 of the Constitution, and this is, remember, my Lord, this was the debate about control and manage and what all of that means. What we would submit is 207.2 can't be read in isolation from 207.1. 207.1 reads as follows. The President, as the head of the National Executive, must appoint a woman or man as the National Commissioner of the Police Service to control and manage the police service. So the person appointed must exercise some power, and what is the power they must exercise? They must exercise to either control or manage. That's 207.1. 207.2, in our interpretation, with all due respect, tells you how you exercise that power. That's why 207.2 says that the National Commissioner must exercise control and manage the police service. In other words, what 207.1 told him he can do. That's the interconnection between 207.1 and 207.2. And he does that in accordance with the national policing policy and the directions of the cabinet member responsible for policing. So, that's what the Constitution says. Now, the specific act which regulates the police service is the SAPS Act. And there are two relevant provisions of the SAPS Act. The first one is Section 24 of the SAPS Act. And what Section 24 says is that the minister may make regulations, and then it goes on to talk about all kinds of things that the minister may make the regulations about, but that includes things like exercise of policing powers, general management and control, labor relations, and then in particular 24G and the subparagraphs there are 8 subparagraphs, the institution and conduct of disciplinary proceedings, conduct by members that will constitute misconduct, provisions of the Criminal Procedure Act, attendance by a member or any witness at such disciplinary proceedings, the circumstances under which the disciplinary proceedings or inquiries may be conducted, the hearing or submission of the evidence at such disciplinary inquiries, competent findings and sanctions, review and appeal procedures. Now, the relationship of Section 24 then, 24G in particular, says that the minister may make the regulation in respect of this disciplinary topic. And one reads Section 24 together with Section 40, and what Section 40 of the Act says is that, and I'll quote, disciplinary proceedings. Disciplinary proceedings may be instituted in the prescribed manner against a member on account of misconduct, whether such misconduct was committed within or outside the borders of the Republic. So the point is that even though the Constitution is the foundation of the power, once the Constitution gives rise to the SAPS Act, which in turn, in terms of sections 24 and 40, gives rise to the disciplinary regulations, it's the disciplinary regulations that bind the exercise of disciplinary powers by the National Commissioner. And that's why, and now I'm going to read from the bundle of authorities, at 014-593, I don't know if someone can help guide there, 014-593, this is the Masuku judgment, quoting from My Vote Counts. I don't know, my Lord, has anyone helped you get there, or are you navigating yourself? Can someone help the charge? Direct him to 014-593? My Lord, let me try.
Made an attempt.
Is there? Okay, thank you. I'm indebted. Paragraph 102 of that judgment, where it quotes from My Vote Counts, and just listen to this with all due respect. It says, Once legislation to fulfill a constitutional right exists, the Constitution's embodiment of that right is no longer the prime mechanism for its enforcement. The legislation is primary. The right in the Constitution plays only a subsidiary or supporting role. Ultimately, the effect of the principle is that it operates to ensure that disputes are determined using the specific, often more comprehensive legislation enacted to give effect to a constitutional right, preventing them from being determined by invoking the Constitution and relying on the right directly to the exclusion of the legislation. So you'll remember, my Lord, you posited to me that the National Commissioner says I'm relying on 207 and I can rely on this power to do so. It's outside the disciplinary regulations. And I say exactly. The moment the National Commissioner says he is taking himself outside the specific piece of legislation, the regulation, which is promulgated in terms of Section 40 of the SAPS Act, read with Section 24 of the SAPS Act, which gives effect to Section 207 of the Constitution, the National Commissioner is no longer allowed to do that. And the effect of that, my Lord, is that if that regulation does not create a stay-at-home power, then, with all due respect, the debate ends because that's an exercise of power by the National Commissioner that he does not have. Let me illustrate this, if I may please, with respect to a judgment that is cited by our learned friends. It's a judgment called South African Police Union versus Minister of Police and others. And I just want to highlight a few paragraphs in that judgment. This is a judgment relied on by my learned friend's client. If you go to 014-731, that's 014-731, paragraph 79, this court said, Section 40 of the SAPS Act provides that the National Commissioner and employer may institute disciplinary action against any employee who commits misconduct. The prescribed manner is set out in the disciplinary regulations discussed above. So, the point here is that not only does the principle of subsidiarity tell you that the way to approach this disciplinary issue is via the regulations and not the Constitution, this court itself has endorsed that the regulations are the principal instrument through which you establish whether the power exists or doesn't exist. So if you turn back by one page, 014-730, what you'll see, and this Justice Davis takes us back to something we were discussing earlier, para 66 of that judgment, it says, it is the National Commissioner's prerogative as the employer to initiate investigations and disciplinary action. Then it says at paragraph 69, the National Commissioner has the power to suspend in accordance with the entitlement to do so in terms of Section 40 of the SAPS Act, read with regulations 4, 5, 8, and 10 of the disciplinary regulations. And then it goes on to say, you will see at paragraph 70, there's a concession made by counsel in that matter that the relevant employees were indeed members of the SAPS Act. That's still on 014-730, paragraph 70. But then if you go over the page again to where we started, at 014-731, you'll see that the conclusion reached in 78 doesn't apply here in this matter, because in 78 what it says is, it says, from the papers, it is clear that all the legal prescripts have been met for the lawful suspension, pending the internal disciplinary process. But, as we've just been debating, if there's no power in terms of the disciplinary regulation, you can't then invent that power having regard to Section 207. The only instrument that regulates discipline in the police is, with all due respect, the disciplinary regs, and if there's no power to stay at home there, well then you can't give an order to anyone to stay at home. So let's go back then, before the tea break, we were discussing SS1 at 001-58, and you'll remember I'm still addressing you on the power and whether or not there's a power to order the stay-at-home order or to give the stay-at-home order. Now you'll see that at 001-58, paragraph 1, we read this out earlier, so I'm not going to spend much time on it, but you'll know that this notice is purportedly in terms of Regulation 8.1. Now, if you keep one finger there, and if you go to 001-96, which is in the regulations, towards the bottom of the page, what it says is the following. It says, at 8.1, a supervisor must ensure that the investigation is completed within 30 days, and if satisfied that the alleged misconduct is of a serious nature, the holding of a disciplinary hearing, refer the outcome of the investigation to the employer representative within 7 working days to initiate a disciplinary action. The employee must be informed of the alleged misconduct and pending investigation. And then 8.2 on that same page says, the employer representative must within 15 working days charge the employee with misconduct by serving a written notice to attend a disciplinary hearing in the form determined by the National Commissioner. And if you carry on reading Regulation 8, the point, let's actually do that at 001-97, Regulation 8.3, Regulation 8.3 talks about the written notice of the disciplinary hearing. And it says what the notice of the disciplinary hearing must contain. It does so at subparagraphs A to D. And then sub 4 and 5 talk about service. Now, why do I take you to that? I take you to that because what we know is that after SS1 is given to Lieutenant General Sibiya, the stay-at-home order emerges. And the stay-at-home order keeps him at home pending whatever investigation is said to be happening or not happening. So the first point is that this stay-at-home order is self-evidently not authorized by Regulation 8, because Regulation 8 doesn't permit the National Commissioner to issue such an order, even where there are allegations of serious misconduct. That's point number 1. Point number 2, and this takes me back to the debate that Justice Davis and I were having, and in fact, I'm grateful to Justice Davis because he posited a number of qualifications at me. He said, did General Sibiya get paid? Did he have security? And so on. And the conclusion there was reached that, well, then isn't that a precautionary suspension? Now, if that is the case, if it is a precautionary suspension, and then the long principles apply which might clothe the National Commissioner's powers with some degree of lawfulness, let's look at what the regulation itself says. If you go to 001-99, this is again back in the disciplinary regulations. Does the court have it? I'm getting indications, I'm indebted. Halfway on that page, 001-99, suspension. A suspension or temporary transfer is a precautionary measure. So this is, Justice Davis, the debate we were having earlier. But look very importantly what it says at 10.2. The National, Provincial or Divisional Commissioner may suspend or temporarily transfer an employee provided that before effecting such a suspension or transfer, such an employee is afforded a reasonable opportunity to make written representations. So if you just stop there, and we accept, Justice Davis, having regard to the debate you and I had earlier, that the National Commissioner does have a power of precautionary suspension. What we know is that 10.2 sets out the requirements it has to meet before that power is lawful and can be effected. And if you measure 10.2 against what we just spoke about in SS1 and SS2, you will see that there is absolutely no provision for Lieutenant General Sibiya to make any submissions whatsoever. Because what happens with SS1 is he just gets told about the alleged misconduct, and SS2 is that he's told to stay at home. So, if it is a precautionary suspension, well then it's dead in the water because it doesn't comply with Regulation 10.2. I've just shown you that. But if it's not a precautionary suspension, it's still dead in the water because Regulation 10.2 is the only thing that regulates staying at home or suspension or not coming to work. And so if there's no power to order such a stay-at-home order, then the point to be made is that it doesn't comply with 10.2 as a precautionary suspension. And worse still, even if there is full remuneration and all those kinds of things as discussed in 10.3, the employer can only make that decision after having afforded the employee a reasonable opportunity to make written representations. So that's the dilemma that Lieutenant General Sibiya finds himself in. When SS1 comes about, it's told that you're being informed about these allegations. All right, fine, we're informed about those allegations. But then the very next thing on the same day is SS2, which says stay at home. And there's nowhere in the regulations that says that the National Commissioner is allowed to tell anybody to stay at home. The closest the stay-at-home order comes from is Regulation 10, and I've demonstrated to you how, on any interpretation, the stay-at-home order can never meet the requirements of 10.2 because there was no opportunity to make representations. And worse still for the National Commissioner, because of what I read out to you from Masuku, and because of how I've explained the principle of subsidiarity and the interrelationship between 207 of the Constitution, 24 and 40 of the SAPS Act, and the disciplinary regs, the National Commissioner is not allowed to go back to the Constitution and invent a power that the specific regulation does not give him. So insofar as the stay-at-home order is concerned, and I'm only limiting myself to the stay-at-home order for the time being, that is unlawful. And it's unlawful because of a simple non-compliance. Simple non-compliance. So that's where we are. Now, if the court then has regard to, still in the disciplinary regulations if I may, 001-93, this is regulation 5. No, I lie. 6. Disciplinary officers. 6. 001-93, my lady presiding. And the particular regulation I'm looking at on that page is Regulation 6, headed disciplinary officers. Now, all I want to point out here is that what we are told by General Masemola is that he appointed someone as an investigation officer, General Patekile, and that General Patekile was an investigation officer and he performed some or other investigation. We don't know what the outcome of that investigation is. It's not on the papers. So the first point I would make is, if the investigation is concluded, what's the point of a precautionary suspension in circumstances where the very thing you're trying to protect on the respondent's version has already been done? There's no purpose to continue with the stay-at-home order in whatever manner it's described, stay-at-home or anything else, because the investigation has concluded. And if we applied the principle of Long versus SA Breweries, keeping Lieutenant General Sibiya at home whilst the investigation has concluded then converts an otherwise precautionary suspension into a punitive suspension. And that would also then be unlawful, having regard not only to the fact that it would be the use of a precautionary suspension power for an ulterior purpose, it would also be ultra vires Regulation 10. So the spaghetti, the procedural spaghetti that our learned friend's client has tied himself into is what we're pointing out here is the breach of General Sibiya's rights. And at the very least, that entitles General Sibiya to prayer 2 of the notice of motion, which is to set aside the stay-at-home order as not being authorized in law. And I don't want to repeat myself from earlier, but that's why the authority relied upon by our learned friend in freedom under law is in fact against him, not in favor of him. Because what freedom under law emphasizes is that the SAP's commissioner's powers is limited by the discipline regulations. That's at paragraph 218 at 014-202. The court doesn't need to go there, I read it out earlier. I'm just re-emphasizing the point that all the authorities tell you that it's only the regulations. And the commissioner himself says, well, I acted outside of them. Game over, with all due respect. If the very repository of the power says I acted outside the terms of the enabling instrument in terms of which I exercise public power, that's ipso facto unlawful. That's affordable medicines, that's pharmaceutical manufacturers, that's all of those cases we discussed earlier. So that's why prayer 2 of the notice of motion falls to be granted. Whilst I'm on that stay-at-home order, some gizmo has fallen down here from the media. I don't know what that is, but anyway. Whilst I'm on that stay-at-home order, let's just test the logic of what the National Commissioner says. And I want to adopt then the National Commissioner's logic that he is entitled to give the stay-at-home order. Let's just assume he has that power. What does that mean? Well, then it means that the content of Regulation 10 would be rendered redundant, because every precautionary suspension could be labeled as a stay-at-home order, and all of the protections that are afforded to employees in terms of Regulation 10 would be taken away merely because the National Commissioner says, well, I'm not giving you a precautionary suspension, even though, Justice Davis, your stay at home is with pay, it's with your security, it's with your full benefits, which, by the way, sounds like a precautionary suspension.
No, the contrary. For considering a precautionary suspension, those elements might be considered by the person issuing it.
Agreed.
Here, there is no such consideration. There is no impairment on any of the pre-existing remunerative provisions. It was just staying away from your...
But this is the point that I'm making, is that if you are willing to accept that distinction, with all due respect, you're accepting form above substance. Because what that stay-at-home order does, apart from the fact that it ticks similar boxes to a legitimate precautionary suspension, like we were discussing earlier, like you've just posited to me, pay, remuneration, security, conditions of employment type of things. If that is the case, then the fact that, apart from the fact that there's no such thing in the regulation, it means that Regulation 10 would be pointless. And you know that the approach to statutory interpretation is that you never interpret towards redundancy. You always interpret towards having effect. And if that is the case, then you'd have to ask yourself, why is it that a stay-at-home order, which looks like a precautionary suspension, smells like a precautionary suspension, probably for General Sibiya even tastes like a prescripts of Reg 10. And if it is then taken outside the prescripts of Reg 10, then it's unlawful, because there's no statutory basis upon which a stay-at-home order can be issued, particularly where the effect of that stay-at-home order is indistinguishable from a precautionary suspension, because, as the applicant says, the stay-at-home suspension, the stay-at-home order is effectively a precautionary suspension by another name. That's the point. And so if there's no legal authority for that, that decision then falls to the wayside. Whilst I'm on that, can I just say that there's a dispute between the parties about, there's a dispute between whether General Sibiya does have security or doesn't have security. Is he being provided with resources? Is he not being provided with the resources? May I just give the court one reference, if I may? We don't dispute the fact that he's got full remuneration, but you know that the security issue is an issue that is in dispute between the parties. What you will know from the record is that, and if you'll bear with me, here we are. You know that in the founding affidavit at 001-52, paras 211 to 214, Major General Sibiya says that the risk assessment confirms the high threat on his life and recommends that he be afforded static and transit protection, and he goes on to say that he was not afforded that. What the National Commissioner says in response to that at 003-49, all the way up to 003-51, paragraph 41.4 to paragraph 42.8, is he says that the National Commissioner ordered that Sibiya be provided static and transit security, and a team was deployed, but Sibiya withdrew the team because he was unhappy with the selection. And then what you know in the replying affidavit, having regard to the risk assessment, is at 004-60 at 251, para 251 to para 254. Sibiya says, given the sensitivity, he asked that he would be able to choose his security because he can trust them, and given that there is hostility inside and outside the SAPS towards him, and more than that, that on 31 July 2025, the SAPS itself prepared an information note recommending that Sibiya be allowed to choose the team he trusts. Now, the reason I advance that in front of you is because, again, to the extent that this stay-at-home order is a disguised precautionary suspension, that depreciation in benefit, pre-being made to stay at home and post being made to stay at home, is an unlawful consequence of an unlawful decision. And we say that because there's no statutory authority for that decision, that adds further credence as to why it should be reviewed and set aside or declared unlawful, as the case may be. Now, if I may then move on to paragraph 3 and 4 of the notice of motion. That's the interdict and the alternative suspension prayer. Let's start at the beginning. And the beginning, what I have to say about in the beginning is this. At 001-63, the terms of reference for the Commission say the following. The Commission is appointed to investigate and report on the veracity, scope, and the extent of the allegations with regard to the infiltration of law enforcement, intelligence, and associated institutions within the criminal justice system by criminal syndicates, and here's the important part, and make findings and recommendations for criminal prosecution, disciplinary action, and institutional reform. Now, why that's the important starting point is, you'll remember in the morning when we were debating, particularly between Justice Moshoana and myself, as well as Justice Davis and myself, we were trying to tease out what's the interrelationship between a parallel disciplinary process and the Commission. I'm going to leave aside the lack of powers for the time being. I've dealt with that argument. I'm not going to repeat myself. Let's just move on now to the interrelationship between the two. This is the point. The point is that insofar as prayers 3 and 4 is concerned, the attack on the National Commissioner's insistence on disciplining, at this stage at least, is not to invalidate for a rule of law reason or to say that it was unlawfully taken or whatever. That's actually not being challenged in front of you. What the relevance is is that in a situation where my client, Lieutenant General Sibiya, faces two processes, one under General Masemola and one under the Commission, he comes to the court and he says, I'm not asking you to invalidate what Masemola is doing or not doing insofar as the institution of the investigation is concerned. For that disciplinary process, which was either previously started or this new one in terms of the Section 10 notice that we debated earlier, I'm asking you to interdict it. And I'm asking you to interdict it because it is a breach of my rights. And where he says it's the breach of his rights from is that it comes from inter alia, the issue about the conflict, the issue about the double jeopardy, the issue about conflict, double jeopardy, the further issue about whether or not it's an abuse of process, and all those other kinds of allegations which are on the papers. Now, why that's important is because when the court comes to consider the interdict prayer, unlike in prayer 2, it's not being asked to make a final determination on lawfulness of the institution decision. It's not being asked to do that. It's being asked to grant an interdict in circumstances where it can be demonstrated that if the process under General Masemola is allowed to continue, it will have a prejudicial effect on General Sibiya's rights. And in that scenario, rather than let that process go ahead, stop that process and let the Commission, who doesn't suffer from all of the problems that General Sibiya says General Masemola suffers from, let them do that. And because the Commission has the power to make recommendations on disciplinary action and all those kinds of things, the point to be made is that the Commission is the more appropriate forum. So the interdict prayer is different to the prayer in prayer 2. The prayer in prayer 2 is a final prayer on a rule of law challenge type point, ultra vires. Prayer 3 and prayer 4 is asking this court to exercise its discretion about whether or not it issues an injunction or doesn't issue an injunction. And that's why when I started in the morning and I said, you know that the test is prima facie open to some doubt, that's what General Sibiya has done. 3 interdependent reasons which demonstrate that if the Masemola process is allowed to continue, his rights are going to be prejudiced. This court might not agree. This court might think, well, you know, I'm not convinced and whatever, but that's not the test. The test is, even if open to some doubt, is there an infringement to the prima facie right? And if you accept that an employee at first principles is entitled to a lawful disciplinary process, and then what is placed in issue is the very lawfulness of that disciplinary process, even if this court is not convinced, the fact that the existence of that prima facie right, though open to some doubt in front of the court, is what triggers the interdictory relief. And that's what we say is the fundamental difference between prayers 2 and 3, and why, however, flowing from prayer 2, prayer 3 can, in fact, be granted. And I would like to, if I may, just go to one of the authorities that my learned friend's client relies upon. It's the Minister of Police Authority versus Premier of the Western Cape. And I want to draw attention to paragraph 54 of that judgment, which can be found, if I'm not mistaken, at 014-149. 014-149. And let's just look at what paragraph 54 says. We need to examine this together because remember, what prayer 3 and prayer 4 is asking this court to do is it's asking the court to exercise a discretion about which disciplinary process should be given the opportunity to run. And what our learned friends say is that, well, these two things can operate side by side, and because they can operate side by side, there's no basis for the interdict. But look at how the court, the constitutional court, reconciles these two things together. It says, and this was, and I'll admit this was in the context of a subpoena, but it says the following. And I'm reading about 3 lines down in that paragraph, 4 lines down in that paragraph. Even if a police witness were to appear in person, ordinarily it would be over a limited time. Secondly, the mere attendance of the police at a hearing cannot possibly usurp the general management and control of the police service and their day-to-day activities. When required to testify before a commission, a police officer may raise any lawful objection to the production of particular evidence. It is trite that a subpoena issued by a commission must be lawful. It may not travel beyond the mandate of the commission or be otherwise defective. If it were so, it would be open to the police service to have it set aside. So let's just pause there. How that's relevant to this dispute is that the Constitutional Court tells you is that a commission and the general power can exist side by side, and that where the commission does exist, it can act within the scope of its mandate. And what we know is that this commission's scope of its mandate includes disciplinary action. And so even though the National Commissioner may still retain, in theory, a power to discipline, the question the court has to ask itself is, would allowing that process to continue advance the law or retard the law? And we would say that in the context of these specific facts, where the very person who is in some way sitting in judgment of Lieutenant General Sibiya is also himself implicated in the very, potentially implicated, let me say, potentially implicated, in the very wrongdoing that is relied upon by that individual, General Masemola, to suspend or make him stay at home, General Sibiya, that surely cannot be an advancement of the law in this situation. And what's important about this is to remember that we're not asking that all disciplinary action against Lieutenant General Sibiya fall to the wayside. It's very specific. It's saying it's only those disciplinary issues that run concurrently with the terms of reference of the Commission of Inquiry. And what does that do? That does 2 things with all due respect. One is it preserves a process that allows Lieutenant General Sibiya to be disciplined in respect of the Mkwanazi allegations by an independent, neutral arbiter being Justice Madlanga and advocates Baloy SC and Kumalo SC, who are not themselves implicated in making these kinds of decisions, potentially implicated in making these kinds of decisions. But what does it also do? It also allows Major General, I think he's Major General, the National Commissioner, General Masemola. It allows him to discipline potentially Lieutenant General Sibiya for all kinds of other issues that fall outside the terms of the Commission of Inquiry, and the interdict only serves as a small break on his otherwise full set of powers, and the reason for the small break on that otherwise full set of powers is as addressed in the papers, because the Commission is the more appropriate body to do so. I'm not going to read the authorities, you will know them, but there are ample authorities that talk about the doctrine of nemo iodex in sua causa, where no party may sit in judgment of themselves. In our heads of argument, we make reference to the Liebenberg judgment, paragraph 55. And in fact, maybe I should read it out, because this adds the context as to why the interdict is important. It says, the very idea of adjudication, and you will remember General Masemola is adjudicating to an extent my client, at least in the preliminary stages. The very idea of adjudication connotes impartiality, for the integrity of justice is threatened as soon as self-interest, actual or probable, in the mind of the person adjudicating is tolerated. And that's the very point we're saying here. We're not asking this court to say he is conflicted. We're not asking this court to say he's not conflicted. We're saying if the court can say that Major General Sibiya has laid out a factual basis for a reasonable perception of conflict, then that would violate the principle articulated in Liebenberg. And that's the point that we are saying. The judgment went on to say that so strict are the courts that even where justice would seem to have been done by persons unaffected by bias, yet the mere presence at their consultation of a non-impartial official will vitiate the proceedings. So in other words, what the authorities tell us is that when someone is going to be disciplining another, it's not actual bias that necessarily excludes them, but it's a low bar, in the words of the court here, where the mere presence of a non-impartial official will vitiate the proceedings. And it cannot be doubted that given the factual contest between General Sibiya and General Masemola, which will be resolved elsewhere, not in this court, that is sufficient conflict for the purpose of the interdict, because otherwise, if General Masemola is allowed to be both the complainant, the prosecutor, the decider, and the potential appeal body, that vitiates the proceedings in the way in which we complain about here. And as you will know, the exhaustion of the court is, justice must not only be done, but it should manifestly and undoubtedly be seen to be done. And we say to you that justice would not be seen to be done in these circumstances if the very person potentially implicated in these situations is allowed to take disciplinary action against my client. So that's the reason that prayers 3 and 4 fall to be granted in favor of my client. Can I just give some authority as further support for this? Because what you'll remember, or maybe this is the argument, let's just say the court is against me and doesn't grant the interdict, or the court chooses not to suspend. Then what my client would be forced to do is he would be forced to review potentially in due course and undo the illegality that he complains about. But what we know is that the Constitutional Court has said that that sometimes is too little too late. At 014-252, in the Glenister judgment, penned by then DCJ Moseneke and then Justice Cameron, in the context of IPID, some of the members of the court might be familiar with this, but in the context of setting up setting up the Hawks, the DPCI. So we're talking about very serious criminal justice issues. The court said, in short, and I'm reading from para 247, in short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, very serious and obvious limitations. In some cases, irreparable harm may have been caused, which judicial review and complaints can do little to remedy. And so the point we make is that by Lieutenant General Sibiya coming to the court and asking for the interdict, alternatively the suspension prayer, he's forcing, in effect, under the authority of the court, that whatever disciplinary action is going to be taken against him is a lawful disciplinary action or a more lawful disciplinary action ab initio. Because if he were forced to be subjected to a disciplinary proceeding that was subsequently found to be unlawful, the harm and the damage is too little, too late, based on the strength of what the court says in Glenister. And that, with all due respect, is something that can't really be overlooked. And this is not surprising, because what the court will know is that that obviously deals with the interdict standard. Prima facie, right, though open to some doubt. But the court has developed its jurisprudence. In this court, if I'm not mistaken, it was our current acting Deputy Judge President, sitting as the High Court alone, in the matter of Gordon versus the Public Protector. If you'll bear with me. Here we are. Gordon versus the Public Protector. In the context of disciplinary proceedings, because you remember the public protector's recommendation in that matter is that Minister Gordhan must be subject to disciplinary proceedings. Minister Gordhan then brought the interdict, and the dispute in front of Justice Molopa Setosa, our current acting deputy judge president, is whether or not the interdict should be granted. And when the interdict was being disputed, then Minister Gordhan, now the late Minister Gordhan, had filed a review application, and prima facie in the interdict relied on the issues canvassed in the review to establish his prima facie right for the purposes of the interdict. And look at what Justice Molopa Setosa says. She says, the harm to Gordhan speaks for itself. The harm would be irreparable if the interdict is not granted. Being prosecuted, disciplined, and investigated most certainly constitutes harm, and the harm may be irreparable and irreversible by the time the review application is heard, especially so if the review application is successful. The judge went on to say, there is no harm to the public protector or her office if the remedial action is suspended pending the review. This is not a final order, and if the review is to be unsuccessful, the remedial actions are to commence. This matter constitutes a clear case where judicial interference is warranted. The public protector and her office can fulfill her constitutional duties with the suspension order not interfering with them. Suspension of her orders has most certainly not interfered with her constitutional duties in other matters. The mere fact that the parties have abided to the court decision is not an acquiescence to the remedial orders of the public protector. So how does that apply here? What Justice Molopa Setosa says is that when you are subjected to the review, or when you are subjected to the disciplinary action which is going to be challenged in the review, if the review is successful, well, then you should never have been subjected to that in the first place, self-evidently. But what she says is if the review is unsuccessful, well, then you can do your disciplinary conduct whenever the review is dismissed. Applying that logic to this case here means that the interdict, with all due respect, should be granted, because we say there are serious questions about the lawful ability of Masemola to be involved with all of that, and that's why the commission is the more appropriate body. And it's actually even better than the situation than Minister Gordhan, because you'll remember in Minister Gordhan's case, the issue was no remedial action, wait until the review outcome, then decide what to do. Here, it's actually better in the favor of the SAPS, because we're not saying hold off the disciplinary action forever. We're just saying you, National Commissioner, don't take the disciplinary action, let the Commission of Inquiry do it. And so if there's any allegation of harm that the National Commissioner himself or the police as an institution lose an ability to discipline a member of theirs, that's actually not true, because the Commission will plug the gap. And if the Commission then decides that there's nothing for General Sibiya to answer for, nothing prevents General Masemola at that stage to try discipline again. But the point of the matter is that in this phase of the initial discipline, the question the court has to ask is whether or not it should permit my client to be subject to a disciplinary process where there's the question of inter alia, the conflict of one of the principal decision makers involved in making these decisions against him. And look at what and remember the Gordhan matter was taken on appeal to the Constitutional Court. You'll remember that. And in the minority concurring judgment of Justice Jafta, as he was then, in which all the members of the court concluded, the court said this. I'm reading from para 113, which can be found in our bundle of authorities. Someone will give me the reference to the bundle of authorities. But at para 113 of that judgment, and I'm reading about midway in that judgment, the court said this, and this is why it's important to bear in mind that prayers 3 and 4 are pleaded in the alternative to each other. Even if it could be said that there were prospects against the grant of an interdict, in other words, you're not with me on prayer 3, the applicants for leave would still be faced with the question whether there were prospects against suspension. Requirements for suspension differ from those needed for an interim interdict. The outer standard, and you'll know our learned friends try to argue both outer and setlogelo against us in the context of the interdict, which is fine. We say we come home on the interdict standard anyway for the reasons that I've addressed. But the court said the outer standard does not apply to suspension. The court goes on. The power to suspend the operation of the public protector's remedial action is sourced from section 1721B of the Constitution. If in a matter like the present, it is considered just and equitable to suspend a remedial action pending a determination of the review in which the validity of the remedial action is impugned, a court may grant the suspension. Guidance for issuing the suspension is derived from considerations of justice and equity. And that's why the court is being asked in the alternative, an interdict or suspension, is it in the interest of justice to subject General Sibiya to this kind of disciplinary process for all the reasons we say he shouldn't to, and where the Commission can plug the lacuna? The court went on to say at para 115 of that judgment, a determination of just and equitable order of necessity requires a careful consideration of interests of parties on both sides of the litigation. The order must be fair and just when all relevant factors are taken into account. What is just and equitable in a given case depends on the facts of a particular case. This sort of inquiry entails a flexible approach in pursuit of justice and equity in every matter. Now let's take a step back. If General Masemola says, I have to discipline General Sibiya, is that for the outcome of a potential disciplinary inquiry? Or is it because he wants to be the one at the center of the disciplinary proceeding? Obviously, if it were the latter, the argument becomes potentially arbitrariness, capriciousness, abuse of process, mala fide, and so on. Okay? And we're not saying that is what General Masemola wants to do. We're giving him the benefit of the doubt. So if we give him the benefit of the doubt, and the effect of his disciplinary conduct is to achieve a disciplinary outcome, why is it not in the interests of justice and equity to allow the Commission to undertake that disciplinary conduct in circumstances where there are questions over General Masemola's ability, capability, and lawful standing to do so? What you'll know from that Godin judgment is the Godin judgment was emphatic to say, don't allow the exercise of a public power purely for the sake of expediency. In other words, exercising that power for the sake of exercising that power. The court is enjoined to take a more interrogative approach as to whether or not the exercise of that public power in the circumstances would constitute something that could be defensible in the interests of justice. And what we say to the court is that we are not in that territory at all, for all the reasons that I've advanced in front of you. And that if General Masemola's disciplinary process is allowed to go ahead, then we're going to be setting ourselves up for a review in due course, irreparable harm, too little too late, contradict Glenister, contradict Godin High Court, contradict Godin Constitutional Court. Really, what are we doing here in the first place? And so we'd say with all due respect, that's something that this court should not permit to go ahead. Let me talk about the evidence, if I may. I'd like the court, please, to go, because we were talking about the answering affidavit earlier, and I think maybe it's time for us to do a little bit of digging in the answering affidavit. If the court goes to 003-33, paragraph 23.2, look at what he says. I am mandated in section 207 of the Constitution to control and manage the police, and then he goes on to say, in line with national policing policy and directions from the Minister of Police. So that statement tells you he recognizes the importance of the disciplinary regulations, but that to justify his power, he says he can go behind all of that to 207.2 and sidestep that very same disciplinary regulation to achieve the effective precautionary suspension, which he styles as a stay-at-home. That obviously is not lawful and is something that should be placed in doubt when the court considers this. If the court turns over at 003-34, paragraph 23.6 of the answering affidavit. Look at what he says. I appointed an investigation officer, Lieutenant General Patakile, to conduct a preliminary investigation.
Not to interrupt you, but we've read the papers. We'd like you to advance and possibly also conclude your argument.
May I make 3 brief submissions on that paragraph then that I was referring to? In the first instance, there's no such thing as an investigation officer. Go read the regulation. In the second instance, the only disciplinary power that is permitted is a disciplinary officer. That's Regulation 6. The paragraph refers to Regulation 8.1. Thirdly, insofar as the absence of the employee is concerned, that's confirmed. That we say is supportive of our case. So if I don't have to read the paragraph, which I'm grateful for, the legal points stand in the way that they do from the papers, in the way that I've mentioned them. Urgency. 3 cases, if I may.
That's not an issue. The matter started out as an urgent application at the request of your client. A special court was constituted to continue that urgent application, which is now dealing with. Matters of national interest are involved, and we're...
But we did not object the matter in relation to the urgency.
That's different to what was indicated previously. So I'm happy that urgency is no longer in doubt. Eastrock, Apleni, and Letso Honyane stand in my favor. No substantial redress in due course, rule of law harm, and contractual performance of contractual remedy of specific performance. Costs. Simply put, we say that given the absence of lawful authority for the decision taken under prayer 2 of the notice of motion, that concedes the case. My client is entitled to costs there. In the instance where the resistance by the National Commissioner for Prayers 3 and 4 is not grounded in cognizable legal principle for the reasons that I've articulated, we say that the insistence of the National Commissioner to want to discipline in these circumstances is for the purposes of expediency, which has been sanctioned by no less than the Constitutional Court. And given the extent to which the National Commissioner, rather than exercising his duty as stated in Kurland, where state litigants have a higher duty to be careful about how they litigate at the state's expense, particularly on rule of law issues, which this court will know comes from another judgment of the Supreme Court of Appeal in Gauteng Gambling Board, and then also the Constitutional Court in Public Protector versus the SARB, that in those instances costs should be awarded, punitive costs should be awarded, and you'll know on the papers we make a case as for personal costs against General Masemola. However, we accept that this is the urgent court. If the question of costs is going to be an issue that can always be determined at a later stage, in due course, that question should not detain the court. But if the court is willing to give a cost order, we say we're entitled to costs on the scale sought. And what we also say is that in the event that the court is not with us on the merits, we're immunized because of BioWatch, and this is quite clearly constitutional litigation because it's testing powers under the regulation and subsequent disciplinary powers. May I take an instruction? Thank you.
His previous attorneys tried to stop this thing before it happened on the 11th of July, where he asked at least one judge to respond to these allegations before they take any decisions. It's page 001-26.
Keep. Just two notes, if I may. The first one, if I can ask the court to please have regard to what is said at 001-26, which is in the founding affidavit, and at paragraphs 83 onwards of that founding affidavit, what you will know is that as far back as the 11th of July 2025, which is several days before these notices came out, SS1 and SS2, my client, General Sibiya, said, don't do this to me, and if you're going to do it to me, at least give me an opportunity to make representations before you act against me. That was then not responded to, or it was responded to late, and no opportunity to make representations was afforded. And that, with all due respect, compounds the unlawfulness that I spoke about earlier in the context of how you read regs 6, 8, and 10. That's the first point. The second point, if I may, is just to point out something to the court regarding the first supplementary affidavit, which I understand has been admitted into evidence. If we can please go to that first supplementary affidavit. What? 9-2. I'm indebted to my learned attorney. The application to introduce starts at 9.2. I want to go to the affidavit itself, which starts at 009-6. That's the covering page. Over the page at 009-7, what the applicant tells you is that there's a new document that's called a Notice of Intended Suspension in terms of 10.2. He discusses the notice at paragraph 5 at the bottom of that page. But very importantly, at 009-8 in that affidavit, from paragraph 8 onwards, and this goes all the way from paragraph 8 on that page to paragraph 11 at page 009-11. What the applicant tells you is that, and you'll know this because you've read the papers, is that there's a fundamental disjunct between SS1 and SS2, because that's all predicated on the Mkhwanazi allegations, and then suddenly in the middle of these proceedings, after the launch of these proceedings, after even the filing of the replying affidavit, if I'm not mistaken, this notice emerges. And this notice makes out an entirely new case that General Sibiya is apparently going to be disciplined for in respect of Reg 10. And that's the non-compliance with the instructions. Let me pause here. What you know is that in the founding affidavit, General Sibiya is at pains to demonstrate how he complied with General Masemola's instructions, how he produced the dockets plan in coordination with General Rabi, who is an official from General Masemola's office. You know all of those factual averments from the founding affidavit regarding General Sibiya's compliance with what he says was General Masemola's instructions. Okay, if the court doesn't even want to go there, the mere fact that there is a disjunct between this new notice that emerges out of nowhere and then the earlier notices which somehow purport to be in terms of Reg 8 and giving effect to a stay-at-home order demonstrates at least one of three things. Either this notice is too little too late and it's trying to plug the gap that was identified in the pleadings earlier, or it's a duplicative attempt to now ensure that all General Masemola's bases are covered and he's disciplining General Sibiya on every conceptual notion whatsoever. And you'll know that the challenge there we raise is both in respect of prayers 2 and 3 and 4 for the interdict. Or, at the very least, there's a trial prejudice happening here. And that every time my client, General Sibiya, attempts to draw a line in the sand and protect himself, the response, come hither from General Masemola, is, well, now it's no longer about this, it's now about that. And so if you draw a golden line between SS1 in the founding affidavit and this annexure, or annexure SA1, in the first supplementary affidavit, which is at 009-18, if I'm not mistaken, you'll see that that trial prejudice occurs. And that includes, by the way, Justice Davis, the issue that you and I were debating earlier about the introduction of those reasons for the alleged stay-at-home order in the answering affidavit, which wasn't present in the notice when it was filed at the time. So on any conception, we say that with all due respect, we come home on prayer 2, which is the prayer to quash the disciplinary decision. And then furthermore, we come home with all due respect on prayer 3 and 4, which is the pending the Judicial Commission of Inquiry prayers, either to interdict such parallel proceedings, fresh ones or ongoing ones, or alternatively in prayer 4, to suspend those that have already been taken but are in the process of implementation. I'm indebted to the court for giving me as much time as it has, and I look forward to the reply.
You would have noted that since the tea adjournment, we allowed you to develop all your arguments as fully as you wished. And we thank you for the oral argument in addition to the heads. On one aspect, I just still need some clarity.
Yes, Judge?
The argument that you put forward in answer to my learned brother's question about the intersect of the work of the Commission and the disciplinary procedure for having allegedly not complied with an order
Yes.
regarding the dockets. Refresh my memory. When you started referring to evidence, I did interrupt you, but you were on a different topic. What is your client's evidence? What does he say should happen with 121 murder dockets while the Commission continues for an indefinite period?
I'm not sure that he has to say anything about that. Does he?
Well, that's not the question. My question was, what does he say? If your answer is he doesn't say anything, that's an answer.
No, I think with all due respect, we're speaking cross purposes with each other. I'm trying to understand. I'm trying to understand the scope of the question. Is the question, what does he say happened with the 121 dockets, or what should happen?
What does they should happen? You say he didn't say anything.
That's why I asked the question.
Yes.
What is he supposed to say?
Well, the National Commissioner says whatever happened to the ministerial task team, the dockets should continue to be investigated, murder should be continue to be investigated, witnesses should be protected, and investigative procedures should be continued. And that's why, in a failing out fashion, failing in fashion, the docket should be returned to the station and be continued with. And that is why he objected to them being collected and taken to head office. And that's the basis of the charges put in the suspension notice.
Okay.
And you said, well, don't do a suspension notice issue because it will intersect with the Commission. My question is, what did he say that should happen with those documents, and how does that intersect with the Commission's work? About historical facts.
With all due respect, I'm struggling to understand the question, because let's just understand. I'm sorry, my lord, must I respond to you or must I not respond to you now? I'm not sure what you want me to do.
Mr. Premier, generally counsel responds to a question.
Yes, so may I please do so, because I was trying to do that. What I was going to say to you, my lord, starting out from first bases, is that this disciplinary issue and what happens with the dockets or doesn't happen with the dockets resulted in an order for my client to be told to stay at home. The effect of being told to stay at home, one would imagine, is that he cannot do anything operationally whilst that continues. So to the extent that there is a question asked about what he should be doing, my response is I'm not sure that he can be saying anything about what should be happening with those dockets, because he's currently at home and outside the operational remit of what he might otherwise had. But I'm being whispered at.
Yes, I think you're avoiding the question.
No, with all due respect, I don't think I'm avoiding the question. I'm trying to answer the question. Yes, I apologize. Forgive me, Justice Davis.
Sister asked me to paraphrase the question. Let's make it simple.
Please.
The accusation is the Commissioner said here is the plan, the docket should go back to the stations. Investigations should continue. The accusation is your client gave an instruction that all those dockets should be retained and go to the Divisional Commissioner, Detective and Forensic Services. That's contrary to the National Commissioner's instruction. That's the basis for the disciplinary.
Yes.
Now you say, don't stop all these procedures pending the Commission's work because they intersect. Now my question is, in what way does it intersect if the Commission has to see whether there was interference previously in the investigations or in the dockets? How does that intersect with the instruction carry on in future?
Oh, I finally understand the question. Thank you, Justice Davis. I'm so glad for you having paraphrased it in the way. The answer I give is the answer I mentioned earlier about the terms of reference for the Commission of Inquiry. You'll remember what I said is that the specific mandate of the Commission was about disciplinary actions, and one of those specified issues about the disciplinary actions is what was done with the 121 dockets. So, to the extent that there's the intersect, that subject matter will come before the Commission, and if it's found that Major General Sibiya, Lieutenant General Sibiya, has conducted himself in a manner that is worthy of disciplinary sanction, then the Commission will discipline him. Yes. Yes. The investigation of how... I'm sorry, my lady presiding, could you repeat that? No, so I think now, thank you, my lady presiding, I appreciate that. The Commission is not going to be investigating the dockets. They're not going to be doing police work. What they are going to be doing is looking at the conduct of the officials in carrying out orders or not carrying out orders, and evaluating that conduct and deciding whether that's worthy of disciplinary sanction or not worthy of disciplinary sanction. That's what the Commission is going to do. Insofar as what my lady presiding says to me about ordinary police work is concerned, in respect of those dockets, that's something which at the very least falls outside, I would suggest, the remit of my client, certainly whilst he's at home. And insofar as what must happen with those dockets on the advancement of ordinary police work, the relevant officials must take their decisions. With all due respect, I think the difficulty is that my client's version is what it is about his conduct in respect of those dockets, and that is what will be evaluated by the Commission. But what happens with those dockets themselves and what police work is done is a different, is something that doesn't apply. The intersect is about the disciplinary action that may or may not be taken as a result. I'm just being whispered at, if I may. Palpably implausible, it can be rejected on the papers. And we'd say that in this particular case, because there's no legal authority, Plascon Evans isn't something that will shift the legal issue in favor of the respondent if the respondent has no source of authority for that in the first place. It doesn't matter what he tells you, what he thinks the source of authority is. What matters is whether or not the court making the legal analysis determines that the source does give him that power or doesn't give him that power.
I think what you submitted is not answering the question that I raised. And the question is this. On the papers, the National Commissioner says, as a fact,